Good morning, everybody. I'm just going to give it a few minutes before we get started for everyone to filter into the Zoom room. All right, good morning and welcome to session 3 of the Ability Center of Greater Toledo's ADA seminar, Promoting Housing Justice from Barriers to Full Community Access for People with Disabilities, which is co-sponsored by the Fair Housing Center and put on as part of the Ability Center's Access Network. Just a few housekeeping issues. This session is the second of 6 over the next 2 weeks. So if you haven't had a chance to take a look at our agenda and sign up for other sessions, we would recommend that you do so. The link for the seminar website is in the chat. These sessions are captioned. There's a live captioning button at the bottom of your screen that you can use to turn them on. And because we've been approved for CLEs, we will be giving polling questions every half hour. When one appears on your screen, just answer the question and we'll move on with the session. This morning, we have a nationally recognized speaker, Sara Pratt, that we're very excited to have assisting us with this seminar. And Christina Rodriguez from the Fair Housing Center is going to introduce her. So I'll turn this over to Christina.
Good morning. Thank you for joining us on day 2 of the ADA seminar. I am very proud to introduce Sara Pratt. She joined the national civil rights law firm Relman Colfax in 2015 after her retirement from the federal government. Her civil rights litigation practice with the firm focuses on the Fair Housing Act, Title VI of the Civil Rights Act, Section 504 of the 1973 Rehabilitation Act, and related civil rights laws, with an emphasis on challenges to institutional barriers to access to housing, lending, and insurance, and to policies and practices that perpetuate segregation based on race, national origin, and disability. Sara has settled many cases, including cases involving disability rights and accessibility. She serves as an expert witness and speaker on multiple contemporary fair housing and civil rights issues. She was a subject matter expert on accessibility and the Fair Housing Act for the Fair Housing First project, and has trained thousands of developers, code enforcers, architects on the accessibility requirements of the Fair Housing Act. Prior to joining her firm, Sara was Deputy Assistant Secretary for Fair Housing Enforcement with HUD. There she directed civil rights enforcement for HUD nationally and led the development of regulations and policy guidance on numerous emerging civil rights issues. Sara has received numerous awards and recognitions for her work, too numerous to name here. So I am proud to turn it over and introduce our next speaker, Sara Pratt. Thank you for being here, Sara.
Thank you so much, Christina. I'm really pleased to be here today. You know, I work a lot in a lot of areas of civil rights, but disability rights was my first issue when I came out of law school. My husband used a wheelchair and we had a housing search looking for housing that we could use that would be accessible and usable by somebody who used a wheelchair. This was a long time ago and the challenges were, need I say, enormous, especially because at that particular point in our lives, we didn't need subsidized housing. We were looking for market rate housing, and finding accessible housing in that arena was extremely difficult. We ended up renting a place and adjusting it, making changes to meet our needs. So I have a personal interest in accessibility, physical and structural accessibility in housing, and I was thrilled when the Fair Housing Act was amended in 1988 to add disability, and specifically the Fair Housing Act was amended to add particular provisions in it that required newly constructed housing to be accessible. So let's go to the slide about what is covered. When the Fair Housing Act was amended in 1988, it was, again, the Fair Housing Act. Notice, it was not the Americans with Disabilities Act. The Fair Housing Act, please go to the what is covered slide. The ADA was passed after the Fair Housing Act was amended, and the ADA mostly doesn't really apply to housing. And I'll explain in a few places the ADA does pitch in and strengthen and add a few provisions for increased accessibility in housing, but basically the two laws are separate. So if you talk to someone about access to housing for people with mobility disabilities, for example, or sensory or vision impairments, and you're talking to them about this and they start talking about the Americans with Disabilities Act, it's kind of a sure bet that they don't really know exactly what they're talking about. So the Fair Housing Act applies to what is called dwellings. It's a term used in the Fair Housing Act. I'll tell you in a minute what a dwelling is. But it also is a dwelling that was designed and built for first occupancy after March 13th, 1991. So at this point, it's 30 years ago, more than 30 years ago. All properties that are covered dwellings under the Fair Housing Act for accessibility have to have been designed and constructed to be accessible to and usable by people with disabilities. But it doesn't, I would just say right now, apply to older properties that have been renovated. And so you're down by the riverside in your community and you're looking at this Ford dealership that's been changed into condos. And you're thinking that doesn't look very accessible. Well, it might have been built for first occupancy before 1991. So it is really the brand new construction that's covered, but there've been a lot of multifamily properties, a lot of apartments, a lot of condos built in the last 30 years, and they're all covered. Surprisingly, oh wait, maybe not surprisingly, there's still a lot of properties that don't comply with these pretty basic requirements in the Fair Housing Act. So what is covered specifically is a building that has 4 or more built dwelling units in it. It could be a building with 4 or more apartments, 4 or more condos. If a building is a duplex or doesn't have at least 4 units, it's not covered by these accessibility requirements. And then, unlike many laws that have required accessibility in the past, they have a scoping requirement that says this: if the building has at least 1 elevator of any type, could be passenger or freight, 100% of the units are covered. All of them have to be usable by people with disabilities and comply with specific minimum standards for accessibility. If the building doesn't have an elevator, then all ground floor units are covered. Ground floor is a term of art, and it doesn't always mean the bottom floor of a building. I'll explain a little bit more about that. And secretly, here's one of the cool things about the Fair Housing Act. Some buildings have, get this, 2 ground floors. I'll talk about that in a minute too. Next slide, please. So when we're talking about Fair Housing Act coverage, we first of all have to talk about what's a dwelling. And I've already pointed out, we've got apartments, we've got condos, timeshares are covered, dormitories are covered, institutional group homes, that is ones that are not just located in a single family house, but have maybe 12 or 14 units in them or apartments in them for people who are living together. Co-op housing is covered. Nursing homes are covered. Residential hotels that are designed for permanent living. That is where some people come in and they rent in a hotel or a motel week to week or month to month. Those properties are covered, even though they might be called a hotel. Hotels for overnight stays, you know, like the Hilton or the Marriott, are not covered by these requirements. Tax credit properties are covered. Public housing is covered. Project-based Section 8 is covered. Lots and lots of properties. It doesn't really matter about funding. So market rate, high-end penthouse apartments looking out over the lake are just as covered as affordable units built last month or last year for by a community to increase affordable housing in the community. Next slide, please. You'll notice that single-family housing is not covered. Okay, so how do we know about this? How do we get into this? How, if we think there's an apartment complex, maybe where we live or where our friend lives and it's new, and you're thinking this isn't really very accessible, who do you talk to? I mean, I'll tell you a little bit about how you can start your own investigation, or if you're an attorney and someone hands you this case, how you start your investigation. and who you can work with to find out about your rights. So first of all, there are private fair housing organizations and disability rights organizations like the one sponsoring this training who can help you figure out whether you have a complaint or a claim that is a legal claim that can be pursued for lack of accessibility. So those groups, like the one sponsoring this organization, have knowledge about these issues and can assist you. The Department of Housing and Urban Development will do an administrative investigation if you allege with some detail that the property that you live in is covered by the Fair Housing Act, but it misses or it does not have certain important elements of accessibility. And you can call and call a toll-free number or file a complaint online at the link I've provided here. State and local fair housing groups also enforce accessibility requirements. For example, we're in Ohio, the Ohio Commission on Civil Rights enforces accessibility requirements in their laws. And you can also work with a lawyer who can represent you in a lawsuit or in other administrative complaints with respect to accessibility. And these cases it helps if someone knows what they're doing in accessibility cases. So if you're a lawyer taking this training, congratulations. You'll be one of the few people in Ohio who know enough to represent people in an accessibility case. And if you're looking for representation in a case, let me encourage you to consider one of these options on the slide. Next slide, please. So let's talk about, again, what's covered. So I've been saying multifamily housing because that's a shortcut way of saying apartments, condos, nursing homes, dormitories. A lot of people don't know this about the dormitories. And we have seen cases involving dorms that have not been designed to be accessible. Again, constructed for first occupancy after March 13th, 1991. That's a function of when the law was passed and when HUD regulations went into effect to tell people what they had to do to comply. It's a building that has 4 or more units. And you can have a property that has a mix of building sizes and types. Like, properties that have several buildings. You might have a building with 10 units and another building with 10 units. And the building with the clubhouse, there's only 2 units because the clubhouse is there. Those 2 units, believe it or not covered, but all the rest of the properties may be covered. Again, buildings with an elevator, 100% of the units are covered. Buildings without an elevator, all the ground floor units are covered. And all of the public and common use areas, which are all those things that all the tenants get to use. That's the centralized laundry facilities, that's the dog park and the picnic tables and the mailboxes and the club room and all kinds of other areas. Car washing stations are now a feature in some new properties. Well, here's what's not covered. Detached single family houses, right? You go to a subdivision, you're gonna see a house and think about, see some houses and maybe think about building a new single family house, but you notice the single family house is not accessible. It's not required to be accessible. However, notice that the model home or the location where sales transactions occur, even for a single family housing division, that office or that sales office where transactions occur to, you meet with the person on site and you look at the plans and you sign the paperwork. That space has to be accessible, not because of the Fair Housing Act, but because of the Americans with Disabilities Act. And I'm going to tell you something, an interesting story that came out of Texas a few years ago, and I reported in a case. A couple called up to go see a single family subdivision in a community in Texas, in Coppell, Texas, Coppell. And they call in advance and they say, is your office accessible? You know how this goes. Of course, the person answered the phone said, oh, yes, indeed, here's where we are. And then they get there and there's 5 steps up to the front door because they put the office in the first single family house in the subdivision. And of course, it has steps. Then the couple look at each other, shake their heads, and then they get assistance in bumping the wife up the steps because she's using a wheelchair. And they go in and they see the plans and they're interested in they have a conversation about buying a house there. And then as they're taking her out, bumping her up and down the steps, somebody lets loose and she slips and falls and hurts herself. Rather badly, in fact. And so she sued the operator of the single family property, alleging both the Fair Housing Act and the Americans with Disabilities Act had been violated. And because of that, she was injured, physically injured. And the court said the Fair Housing Act doesn't apply because the Fair Housing Act doesn't apply to detached single family houses. However, the Americans with Disabilities Act require that this office, which is a place covered by ADA Title III, everybody put up your hand if you knew that. The office is covered by ADA Title III because it is a public accommodation. It serves the public and it had to have complied with the Americans with Disabilities Act. As a result of that case, and finally some intelligent people coming into play, it is much more likely that you will find offices having to do with sales transactions taking place in houses that are themselves more accessible, or sometimes in the garage space in the house, which has an accessible route to it via the driveway. Duplexes and triplexes not covered. Multi-story townhouses now. That's a term of art, but it really means a townhouse with 2 or more levels in it, not covered. And renovation of pre-1991 buildings also not covered. Next slide. So here's a picture for the townhouse. 2 or more stories are generally not covered. However, sometimes these days you see a townhouse that has an elevator. And because the townhouse has been constructed to provide an accessible route on the interior of the unit, then townhouses in buildings with an elevator are covered and have to comply on every floor with the accessibility requirements. Next slide, please. So this is a picture of the townhouses that are not covered. They're very common design. They have an entrance on the ground floor, but the building itself has got 2 or 3 levels in it connected internally with stairs. So that's not covered. Next slide. And this design, which is often called a carriage house, is also not covered. Why? And we see a million of these days, right? There's a garage on the ground floor, and then you go up some stairs, probably on the inside, and then you have a second and a third floor. Because there are at least 2 stories of finished living space, that property is not covered. Why is that, you say? How come people let that happen? How can they build all those townhouses without making them accessible? Well, here's what I can tell you. There was a congressional oversight hearing about this because a lot of people were concerned about this when this law first passed. HUD said in its regulations that multi-story townhouses did not have to be made accessible. And they said it because the manufactured housing folks, the multifamily housing folks came in and said, well, we can't make all these townhouses accessible. Why, we'd have to put an elevator in every single one. And HUD unfortunately agreed. I was not there at the time, I have to say, agreed to that. And so townhouses were not covered. Many of you know, depending on what communities you're in, have known that there's been a community-based response to all these townhouses that are not accessible by adopting locally visitability standards that require that such townhouses, while they're not required to be accessible under the Fair Housing Act, there may be a local ordinance that says the ground floor unit or the entry level of that townhouse has to be usable by people with disabilities. So flat steps and accessible bathrooms, but not, of course, the upper levels. And that's a definite response to the lack of coverage of townhouses in the Fair Housing Act requirements. Next slide, please. Now here's a picture. I used to live in those tan buildings at the back, and I used this picture because it's such a good illustration. Because here's all these apartments built on top of a grocery store. And the Fair Housing Act requirements apply to all of those apartments, even though the ground floor of the building itself is something else besides housing. And so building units up above a commercial or retail space, there are elevators that go from the street level all the way up to the top of the building. So it is an elevator building. 100% of those units have to comply with the accessibility requirements, even though there's this commercial stuff on the on the ground floor. And the ground floor of the housing, if it mattered, is the first level above the grocery store. In this case, 100% of the units have to be compliant. Every once in a while, you see a building where on the ground floor, it's the Starbucks, it's the grocery store, it's the CVS, and then up above it, they have one level of apartments, one level. That's the one case in all of the Fair Housing Act where for that one level of apartments, there has to be an elevator installed under the Fair Housing Act, and that one level of apartments has to be accessible. Even though it's not on the ground floor, like touching the ground, it is still considered to be the ground floor of the apartment building. If there are more than one level, there's going to be an elevator, and then all of the units have to comply as well. Next slide, please. Okay, this list on this slide and the next slide is what HUD did in this weird situation where Congress did not authorize HUD to set up one single standard. Like under the ADA, you're used to ADAG, right? You know, there's one standard that you go to, and maybe that gets modified a little bit over the years, but it's one standard. They didn't do that in the Fair Housing Act because the housing industry said don't. They fought it at Congress and with HUD and said, we don't want one single standard. We want it to be handled at the state level because the state and local people are the ones who do the inspections. It turns out, for reasons that I'll describe in a couple of minutes, that didn't work for the industry. And so what HUD did instead was to identify these national sort of standards established by groups that set up standards for accessibility and other requirements for housing. And they have, over the years, adopted a whole series of different standards. And HUD has said, if you actually comply with one of these standards, as described here, and you can go to the next slide too, thank you. And on this next slide, you'll see that it's now 13 of them, not just 10, because at the bullet at the last one, HUD has actually added 2009, 2012, 2015, and 2018s of the International Building Code. And if you have a developer who actually complies with one of those all the way through for everything, they will meet the Fair Housing Act standards, and number one, and two, they have a safe harbor. Next slide, please. But let me tell you something. Those local developers actually almost never, in my experience, actually comply with the state or local standards. So it's not. So if there's if a defense in a case that you have is, and we saw this in a case my law firm practiced in Ohio, the other side came up and said, hey, hello, we consulted with, we complied with the state standards, and the state standards are IBC 2016 or whatever it was, so therefore we entitled to a self harbor. But the problem was that they didn't comply with it. They claimed they did, but they didn't really do it. So all of those safe harbors have the same basic accessibility requirements you'd expect in a Fair Housing Act case, which is to say, if you see steps on the outside going to apartments, if you see narrow doors or doors without the special hardware on them, if you have high thresholds, if you see that there's no curb cuts around the property or no accessible parking at all, I can tell you, number one, either the code is not comparable, but also much more likely is the developer simply didn't comply with it. And in a lot of towns, the local code officials don't enforce the local code. There it is, it sits there, you're supposed to comply with it, but nobody comes out and does the inspection for accessibility compliance. And in fact, the Fair Housing Act protects those local code officials and say, you know what, they don't have to enforce the requirements. It's too bad that the Fair Housing Act says that, but I'll tell you why they said it. It's because it would be what they call an unfunded mandate. That is, Congress cannot pass a law that mandates that a state or local government do something without giving them money to pay for it. Because otherwise, you know, the federal government would establish 14 million things for states to do and then leave the states to figure out how to pay for it. So there's a principle of law saying that if Congress can't do that. So Congress couldn't require state or local officials to ensure compliance with the laws. Many advocates have worked closely with state and local organizations that give building permits for these kinds of apartments and condos and other properties, trying to help them educate people who are coming in for permits to build apartments or condos or whatever the property is, and giving them information about this. But the truth is, the law has to be complied with whether or not the developer or the architect knew that the Fair Housing Act requirements applied or not. But in a lot of communities, you can tell that the local people aren't doing that, because you can go in and you don't see just the occasional property that's out of compliance. It's kind of like every single property is out of compliance. One of my clients in another state, and I'll name it, Indiana, I represent the Fair Housing Center of Central Indiana, who have done some really interesting and important accessibility work in their community. They took on a developer that had properties in 6 or 8 very small towns with local code offices that barely exist, and that mainly do sort of, the paperwork part of it, but don't ever inspect properties. And they had used the same format for building their properties for years and years and years. And every one of the properties was 100% inaccessible, except they had an occasional 1 unit that was accessible. And so the problem was that when you went up to the front door of the buildings, which all had 3 floors, no elevator, you went in, you had steps up to the front door of the building, you went in the front door of the building, and you had one of those split level kinds of arrangements where you had to go down 8 steps to the ground floor units and up 8 steps to the second floor units. There's almost no way to make that property accessible, because it was built in such a way that retrofitting really doesn't work. And so that was a significant problem for them in terms of accessibility. And there was requirements that their new properties have more accessible units, and that some units that they had that were flat and did not have those steps be made to be more accessible, even retrofitted to be more accessible in order to settle the case. There was no local code anywhere enforcement of this. And so the property was free, the developer was free to use a design that got them into a lot of trouble and required them to pay a lot of money to settle the case. Next slide, please. So I'm going to, in a few minutes, if this is getting you bored, I'm sorry, but I will tell you in a few minutes, I'm going to show you pictures of issues that show lack of accessible features, and you're going to help me figure out what the problems are. So when you have a property that's being constructed, the Fair Housing Act uses these words, design and construct. And the courts say you don't have to both design and construct. It is that some people design, like architects, and sometimes civil engineers or landscape designers, and construct, which might be developers, contractors, and subcontractors, and so forth. And so when everyone gets together to build a house, as any developer knows, and anybody who's been around a construction site knows, that you're likely to have an overall general contractor. You will have a lot of subcontractors, and some of the subcontractors will have subcontractors to them. And so you have a lot of people involved who need to know what the rules are and how to follow them. And so when the group of entities enters into the design and construction, all participants in the process can be liable under the Fair Housing Act. So the developer, the owner, the manager, the architect, the civil engineers who decide the elevations of the land, landscape designers who design, where the plantings are going to go and what the elevations might contribute to what the elevations are like, the contractors who put in the masonry or the hardware or the light switches. And then also homeowners associations are responsible not for the design and construction, but might get sued because they are necessary parties to correcting the violation. They will be named in a complaint because they might have to get the votes from the homeowners to make certain changes in a condo association. And in many cases, they may have to pay for some or all of the modifications. Cities, counties, and states that fund housing can be sued. a member of my firm, Michael Allen, some of you may have met him, has sued first the city of Los Angeles and is now suing the city of Chicago because those cities got money from HUD but did not construct the properties that it was building with that money to be accessible. And so you go up the chain. It's not just the developers and the owners and the managers, it's the funder that may also have some liability. If an apartment building is built in 1996 and it's inaccessible and in 2006 it's sold off to someone else, both the original designers and constructors and the new successors owners are liable under a theory of successor liability. So if you can find them, you can sue all of those parties. Real estate agents and lenders, it's less sure whether they could be involved as parties or not, although I've heard theories advanced for each. Real estate agents for claiming that the property is accessible when it's not, which would be misrepresentation, or real estate agents who list properties that are that don't comply. I think that last one is kind of a hard lift. And then lenders, I bet you didn't know this, but the Federal Housing Administration, or we know it as FHA, has a comprehensive set of requirements for purchase of multifamily housing that require, as part of the due diligence when the mortgage is being transferred to someone else, does someone come in to inspect to make sure it's compliant with the accessibility requirements. And they have a map guide that tells lenders that they have to design and construct properties to be compliant with the act. And HUD, the single family office, before they will approve a transfer of ownership, has been requiring that the prior owner remediate or fix the lack of accessibility before it'll approve a transfer. This is amazing and a very big powerhouse. But when I was working at HUD, single family would call up and say, they say that we've identified these problems and that indicate lack of accessibility in this property, and we're not going to approve it. But they say that they've entered into a settlement agreement. Can you see the settlement agreement and see if this takes care of all the problems? And I did it. So they were really checking to make sure that the problems were corrected before they'd agree. And now that you've all answered your polling questions or missed them, let's go to the next slide. All right. So we have this idea of all the things that people say when they are accused of discriminating, right? And so what are some of the defenses that people want to claim when they say, when they're accused of discriminating, and they say things like, I didn't know it was against the law. Court rejects that, doesn't matter. It's like, how well would that work to a police officer if you were speeding down a highway and you were going 80 and the officer gives you a ticket and you said, I didn't know it was against the law to go 80 in Virginia. They're going to laugh at you. So I didn't know is not a defense. The requirement's confusing and vague, not a defense. Citing several cases. A wheelchair user can use the premises. This was a Louisville, Kentucky case I followed very closely at the time. They hired a guy who had a disability, but he was a wheelchair athlete. And they filmed him going around a place that was really inaccessible. And they filmed him hopping curbs and going up a really steep ramp and basically trying to prove that the property was usable by somebody with a disability. And the court emphatically rejected that claim, saying that accessibility is determined by compliance with specific standards. And the fact that one person with a disability can use the properties does not mean that the property is in compliance with the law. There was an argument that the law said that you had to, what was covered was the design and construction. And so someone said, well, I didn't design and construct it, so I get out. And the court said, no, design and construct also means design or construct. So if you designed it or you constructed, or if you designed and constructed, you're still liable. The quality built case cited here in North Carolina, this is where the developer said, hey, I didn't know about accessibility. And so you know what? I relied on the expertise of the architect. And the court said that doesn't get you off the hook. You've got an independent responsibility to comply with the law. It's sort of joint and several liability. Fair Housing Act has vicarious liability and even has a regulation that defines that vicarious liability broadly, so that it's not just the people who had their hands on the building. It can be the people who owned it later. It can be the people up the chain who were responsible for the property, even up until the owners of the property or the land where the construction was occurring, can all be held liable for a failure to design and construct, even though they didn't actually design or construct the property. In Memphis Center for Independent Living, they made some changes after the litigation was filed that didn't get them off the hook for the liability for injury caused by people who were discriminated against. And my favorite, that I didn't have any disability applicants who had disabilities. So if one had happened to come in, we would have fixed everything for them. That has a certain attraction maybe to a judge who never lived had the lived experience of having a disability or living with someone who had a disability. But I can tell you, if you drive through a property that's recently built, I'm going to tell you the 6 or 8 things to look out for when you do a drive-through. And I can tell you that if you see those things from your car, you're not even getting out of the car to apply because the property is not going to be very usable for you. By the way, investigations in these cases can be by individuals who are seeking housing and who cannot find an accessible housing or try to visit a property that is inaccessible just to see what it is like on the inside, and who really would have liked to live there, but it is inaccessible and it doesn't comply with the requirements. It can be someone who lives in the property already and has gotten more disabled as they live there and need accessible features and suddenly realize that there's 3 steps up to their front door. It could be someone who does not have a disability, but has friends or family members with disabilities, and you start noticing that there's 3 steps at the front door because you're trying to hike your brother-in-law in for the wedding shower or whatever it is that you're having at your house. And also fair housing groups and disability rights organizations often use people described as testers who can go out and are familiar with these issues, who may pose as home seekers, may take photographs, may ask questions, may see the property both inside and outside the units, and are trained to identify potential issues and to document them. The evidence of testers has been widely accepted in fair housing cases, and those cases are quite successful. And we often resolve such cases pre-litigation based on evidence of photographs and other information that I'll describe in a few minutes. By the way, I'll mention right now, for those of you who don't know, there is an online resource for accessibility for people who want to take a deeper dive into this work and know more about the specifications. I'm going to talk about specifications in a few minutes, what some of the key ones are. But for more details, you can go to the Fair Housing First website. So it's www.fairhousingfirst, all one word, .org. That's the group that Christina referred to as Fair Housing First when she introduced me. I and a really excellent architect named Phil Zook, I still miss him, he died a few years ago, and I worked together to develop training materials on accessibility. But what's of most interest for lawyers, I know there's some of you out there, is there is a key case law outline of accessibility cases, probably somewhat out of date right now, but it covers all the early cases, including some of the cases cited on this page. And it also has a list of frequently asked questions. And this is the most robust frequently asked questions you've ever seen on a website, because it's not like, where is the law found? It is actually substantive questions and answers. And the reason for that is when Phil and I were going all over the country training people about accessibility, people would ask us questions that we weren't sure we knew the answer to. On the spot, we'd probably give an answer and hope it was right, but we would go back and write them up and send them to HUD. And so we write up the question, write up the answer, and HUD would review them and answer the questions for us. And then after HUD approved the answer, it would go on the website. And so for people like developers or lawyers who are looking for help in interpreting some of the specifications and requirements, I say go to the Fair Housing First website. The other excellent resource is the Fair Housing Act Design Manual. Why? Because it's written in plain language for anybody. It has lots of pictures and charts and arrows, and it tells you quite a bit about what some of the common problems are that are confronted in accessible design for housing and how to resolve them. And it answers some pretty important questions about accessibility. Next slide, please. Okay, so suppose you're thinking you want to take on this issue in some way to address a problem, to look at a pattern, to do some enforcement activity. In general, I would say these are some of the steps that you would follow if you were going to make a plan to address lack of accessibility in a particular community. First of all, you start with one property and that you know has some problems. And I'm going to, again, show you some pictures in a few minutes that'll help you figure out ones that may have some problems. Or maybe it's one you live in and you just want to find out some more about what you can do about it. So you identify the property and you try to identify when it was built. Clue, easy answer to this is to go to apartments.com, look up the property, scroll all the way down to the bottom of all the text. And about 80% of the listings, they say at the bottom when the year that the property was constructed. It was part of the information provided by the property when they were giving information to apartments.com for the listing. This is not a commercial for apartments.com, though. Gotta tell you. Okay, but you can also go to the permitting office. The local office often won't answer the phone or is not there. But if you live in a bigger community, you can go to the office, or in some cases, you can find online information about when the occupancy permits were issued for the property. And that's what you're looking for, not the day the building permit was issued, which might have been a long time ago, but when the permits were issued for occupancy, that's the date of the final construction. That's the date you count from when you're talking about a statute of limitations or considering whether the property is covered or not. You can also go to the local tax office or look online for the current owner or operator if it's not visible online. Go to the Secretary of State's office for corporate identification of a corporation, find the agent for service of process, and look for the various information such as the ones listed on the slide: when the property was built, whether there were, how many units there are, photographs and floor plans. I settled a accessibility case involving remedies for 12 fair housing groups and 50 properties located, some of which are located in Ohio, Indiana, Pennsylvania, New York, and Kentucky. And that developer is called Clover. It's referred to online as Clover Group. It has a lot of properties. A good deal of the case for accessibility that we settled about 2 months ago, we settled it for approximately $7.1 million in remedies. That includes a remediation fund to fix issues on the exterior of the property, provide more curb cuts and ramps to get to doors to the property, provide accessible parking places, and then to get rid of steep slopes, make the property more usable for people with disabilities on the exterior. And then in addition, it has a provision for changing the properties on the inside on tenant requests, so that if tenant says, I have an inaccessible patio door and I cannot get out my patio door because there's a rise on the inside of the door and it's 2 inches high and my wheelchair won't go over it. Replacing or modifying the door for greater accessibility, providing wall hung sinks so that somebody in a wheelchair can pull up underneath the sink rather than having to come alongside of it. Lowering light switches and thermostats and a variety of other changes, and then damages for the organizations that were involved in the investigation. Much of that case, this case was settled after a lawsuit was filed. We tried to settle it pre-litigation and could not. So we filed a lawsuit and then settled it. It's now in effect at Clover Properties, although they are correcting the properties on different timeframes depending on where they are located. But a good deal of that case was built on photographs and floor plans that were available online, so that you could look at the design of the photographs of the property and see that there were issues about the primary entrance door, the front door not being accessible. You could look online and you could see that the floor plans had these narrow little vanities that were crammed in a corner where somebody in a wheelchair could not pull up either under them or beside them, because they had the same design, the same inaccessible design in every bathroom in every one of the 50 properties. So this is how you start identifying a property and building, your first round of cases. Lawyers, this is what you would do to determine whether you have jurisdiction or not, and to determine what the data is that you have to discover whether the properties are in fact covered. Next slide, please. All right, the Fair Housing Act, this is not a presentation where I'm going to do 18 hours of technical details, because your head would hurt and so would mine. But I am going to go over the 7 key elements for compliance with the Fair Housing Act. These 7 elements are in the statute, they're in the regulations, and they are described as requirements in the regulations that describe the Fair Housing Act accessibility guidelines. So these definitions are the kind of base from which you build a case. So requirement 1, start with the accessible route. There has to be accessible route in the community. Where do you start that accessible route? Pedestrian arrival area. What's a pedestrian arrival area? Boy, you learn how to code speak when you do these cases. I'm just going to say a pedestrian arrival area, y'all, is when you park your car and you get out of your car and now you're a pedestrian. So the parking lot is a pedestrian arrival area. Another pedestrian arrival area is a bus stop out on a main drag where there's a bus stop in front of the property, and you get off the bus. You get at the bus stop, you become a pedestrian and you're walking into the property. So the first thing you have to know about is that the accessible route starts at the pedestrian arrival area. So if you've got a bus stop down on the main drag, you need to have an accessible route from that main street up to the rental office and to the units. And so many properties, especially those in smaller communities, just don't have a route, and you just have to drive in and park your car. But if you do have the pedestrian arrival area out on the main street, your accessible route has to include that. And that route has to end at the entrance of each and every unit. So starting on the accessible route, say from the parking lot, you have to be able to go through the entire route to get to a unit, which means in and out of doorways, up and down, this, that, and the other, in and out of hallways. A route that is an accessible route has a running slope that is less than 5%, so is not a deep slope, or if it has a slope that's more than 5% and less than 8.33%, it has to have a ramp. I'm sorry, it has a ramp and handrails and meet other requirements. So therefore, the running slope has to be pretty flat throughout the property. And this is something, when you design the property, the civil engineers, the designers of the exterior are supposed to pay attention to. The route can have a cross slope. So that's the running slope is going down the sidewalk, okay? The cross slope is the slope of the sidewalk from side to side. And there's a specification for that that's less, it has to be less than 2%. I'm going to show you a picture in a little bit about why this can be a problem, but sometimes the route is interrupted by roots, or it's interrupted by a very bad design on the side of a hill where the slope is too far. If you're in a wheelchair and you're going down a sidewalk that slopes too far to one side or the other, who knows? Who can imagine what that would do to you when you're pushing yourself in a wheelchair? I imagine there's people who know in this audience. If you're pushing somebody in a wheelchair, you know it too, because what happens is the wheelchair starts to drift to the side with the downhill slope, to the left or the right. And it can be very hard to control your wheelchair. And sometimes wheelchairs go flat out off the sidewalk and into the grass or into the parking lot. It's very dangerous to have cross slopes that exceed 2%. And so it's something that I particularly pay attention to because of real life experience with this setting. The route has to have the proper curb cuts, and there's specific designs that are okay. And let me just advise you right now that going down a pile of asphalt into the parking lot is not an accessible route. It is not. It usually is too steep. It usually lacks handrails. It is usually a sloppy idea of somebody's idea about how to provide accessibility. It does not comply. Routes have to be at least 30% wide. 36 inches wide. It has to be firm, stable, non-slip. The doors on the route have to have at least a 32-inch clear opening. What's a clear opening, you say? Okay, so we're used to thinking about doors being 36-inch doors. And so some doors are talked about as 36-inch doors, and they're from side to side, edge to edge. But a clear opening is the amount of space that the door is open when you have the door open at 90% angle, so a right angle over here, and you measure from the door to the adjacent jamb across the door, and you measure that dimension. Public and common use or doors under the Fair Housing Act have to be at least 32 inches clear opening, and there has to be maneuvering space around them. So somebody in a wheelchair is trying to open the door, has enough space to move their wheelchair. If they're grabbing onto the door and pulling back in their chair to pull the door towards them, there has to be enough space so they can back up and then pull around the door and go in it. And the route has to include accessible hardware on doors and gates. In a case that is very well known to people in this audience, when I visited the place for the first time and we were looking at all the areas where the property was not accessible, I looked at the doors on these flat units. They're flat and they were connected end to end. And nobody had mentioned this before, but I looked and I said, wait a minute, look at that front door. It has a doorknob, and everybody looked at me like I was crazy. But part of an accessible route is to have a door hardware that does not require you to pinch or twist, and a doorknob requires you to do that. Instead, you have doorknobs that can be operated with a closed fist, usually with the lever hardware. And so easily spotted from your place in your comfy car as you drive around the property, but not always thought about consciously when you're looking and thinking about accessibility. So that's requirement one. You have to have an accessible route from pedestrian arrival areas to the entryway to all of the covered apartments or condos or rooms, whatever it is. The second requirement is that you have to have accessible public and common use areas. What are they? Well, that's the stuff that everybody uses in common. I've mentioned this already. Mailboxes, clubhouses, swimming pools, common laundry areas, fitness centers. Yes, fitness centers. What? People with disabilities use fitness centers? You betcha. Okay, the first big element in public and common use areas is parking. Now, I have to tell you that the requirement in this for parking accessibility is not amazing under the Fair Housing Act. It is, first of all, you have to think about how many parking spaces there are that are for residents. And at least 2% of those parking spaces have to be accessible. Accessible parking places have a striped access aisle, a curb cut, and a sign. And they say accessible parking or words to that effect. So that's in the part of the property for residents, and it's not very many, especially if you have a lot of seniors living there, a lot of people with disabilities. This 2% number does not end up being usable, providing enough spaces in many circumstances. Next slide, please. I'll tell you in a minute what you can do about that if it's a problem. But there is also a requirement under the accessibility requirements to provide accessible spaces for visitors. And that means scattered around the property in places where visitors might park. And so it's basically at least one accessible space at the rental or sales office, and a parking space where one accessible parking space every place around the property that is like a common use area where there's parking, like you have parking at the clubhouse, accessible parking place. Tennis courts over there, they got some parking places there, accessible parking there. Parking spaces near the entrances of the building, accessible parking. This is designed to be so that if you've got a spread out property, someone with a disability can get into their car or van from where they are parked in an accessible place and drive to the amenity and end up there and have a place to park when they get there. If they want to play tennis, fine, there's an accessible parking place for them. So there also has to be accessible routes to the public and common use areas. There's a little bit of fussing about how many, if you've got 2 pools, do both pools have to be on an accessible route? I think probably the answer to that is if they're identical, probably 1 is enough, but you sure have to be able to get there from every single living spot in the community. And if one of them is a lap pool and one is a play pool for kids, both pools have to be on the accessible route because they're different pools. There has to be an accessible route to mailboxes, to the clubhouse, the fitness center, yes, and to the jogging trails, the gazebo, the dog park, the picnic tables, the grill areas, and the car wash station. Okay. So the third requirement is doors, and this is pretty straightforward. Next slide, please. So the interior doors on the property, I've said the 32-inch doors, the doors on the outside have to be 32 inches. The doors on the interiors of the units, like on the inside of the apartments, they are required to be a nominal 32 inches, which is 31 5/8 inches. What the heck, you say? What the heck, what the heck, what the heck? 31 5/8 inches is hard to get through in many chairs. It is. I mean, if you've got an athletic one or a very, very small one, no problem. But if you've got one that's larger, 31 5/8 inches can be a real problem. Agreed. You also can get your knuckles banged up if you're trying to go through them. Nonetheless, that's a minimum standard. Why is that? Because the industry came in and said that if you had a 34-inch, what is called a 34-inch pre-hung door, like you go to Lowe's or someplace, and you buy the frame and the door already on the hinges, all of it pre-hung, that a 34-inch pre-hung door, when you open it all the way to 90 degrees and measure it, it's not quite 32 inches, it's 31 5/8 inches. And so the industry came into HUD and said that should be enough. And HUD, to my sorrow, agreed. Now, if I'm really designing it right, I'm gonna either design the doors myself and make them at least 32 inches or wider, with a clear opening of at least 32 inches or wider. But for people who aren't paying attention, a 34-inch pre-hung door will work. Next slide. All right, so the requirement 4 is that requirement 1 got you to the front door and to the hardware on the front door, and the front door or the primary entrance door of the unit has to have a clear opening of at least 32 inches. But once you get inside, you're down to that 31 5/8 inches. But for the doors, but you still have to have an accessible route into and through the entire unit, into all bedrooms, into all bathrooms, and out the patio or balcony door to the patio or the balcony, an accessible route. And this controls things like a high threshold in the to the bathrooms. You know, sometimes they put in those marble thresholds and they're really high. It has to do with how patio doors are installed and used. So there has to be a clear opening of at least 31 5/8 inches at the patio door, because that's a door. And some of the bad ones don't open that wide. They open to 28 or 29 inches, not wide enough for someone in a wheelchair or walker to get through comfortably. And the thing about the patio doorways themselves is from the inside, looking at the patio door from the inside, there should be just the tiniest of threshold, 3/4 of an inch up from the finished floor. Looking at the patio door from the outside, it depends on what the outside flooring is made of. If it's a concrete patio, you're allowed to have a drop of 4 inches. Now, 4 inches isn't great for someone using a wheelchair, but you can turn them around, take them up a little itty bitty threshold and then down 4 inches, and it can work. Why is the 4-inch requirement there? Because the industry came in and said, you know, in places where it rains a lot, and especially on the side of a property which might be hit by rain, water can build up on a concrete patio. And if we don't have a drop there, the water can blow back in through the patio, under the patio door, and flood the property. So they asked for a 4-inch drop, and HUD gave it to them for the concrete space. But if you've got a deck that has, it's pervious, that is, if it rains, the water can go through the deck and down at the bottom, like, you know, slats or maybe a grate. That kind of, with that kind of patio, you're not allowed to have the whole 4 inches. You have to have a smaller drop. Requirement 5 is that generally the ways that you control your environment inside the unit, the light switches, the thermostats, the electrical outlets generally have to be located in accessible locations. There's a few exceptions, like, yes, you can have a few plugs in the floor for a floor lamp. Not every single one has to be between 15 inches and 48 inches. On the other hand, plugs that you put in the kitchen, plugs that you normally use for lamps, plugs that are in the bathroom have to be normally within reach ranges of no lower than 15 inches, no higher than 48 inches for both plugs and light switches. And you measure from the operable part, the place that you're going to use it. So the 15 inches in a plug, which got 2 outlets on it, you measure from the lowest plug. And if you've got a thermostat, this one gets missed all the time. It's supposed to be within 48 inches, but it's from the place that you operate the thermostat. So you have to look at the thermostat. Is it the controls on the top or is it controls on the bottom? Okay. We're still on the 7 key elements of compliance. The reinforced requirement 6 has to do with reinforced walls in bathrooms. You can't see it when you go in a finished apartment, but there's supposed to be reinforcements in the walls around the bathtub, around the toilet, and around the toilet or the shower to allow for addition of grab bars when someone needs to add them, and they get to add them themselves at their own expense, but you have to have the reinforcements in the wall. How do you check for that? Well, first of all, you can ask management, and often people do, but they usually don't know. I've used stud finders. You get an inexpensive stud finders at Sears, Black & Decker version, run it up and down the wall. It'll tell you if there's a stud or wall wooden reinforcements behind the walls after the walls have already been installed. And the 7th requirement has to be with usable kitchens and bathrooms. The main thing here is there has to be a 40-inch distance between the face of the appliance and the cabinet or the wall on the other side. 40 inches, not any 32 inches, not 36 inches like an accessible route, but 40 inches. And that's because, I don't know, if you're in a wheelchair, you like to open the drawers. So you have to be in your wheelchair, you're opening the drawer, you got to be able to pull back a little bit to get that drawer open. And you're supposed to have a 30 by 48 inch clear floor space parallel to the stove and the sink and centered on them. Some of us know very well about a property that we involved and enforcement in the Toledo area where the stove was crammed back in a corner and a person using a wheelchair could not approach that stove and open the oven door successfully, and they couldn't get up close enough to the stove without banging their knees on the door to reach the controls and the outlets and the burners where they might have wanted to be, I don't know, cooking, right? And so these dimensions are important for usability. They're not just made up randomly. They have to do with how a person using a wheelchair or a walker would be able to use the property. And there are specific requirements about the space that you have to provide in a bathroom, again, to a toilet room, again, to allow enough space. People ask me about powder rooms. Powder rooms have limited requirements for accessibility, but they have to have an accessible door. You have to be able to get through the doorway and close the door behind you, because we all like to close the door when we use the bathroom, right? You have to have a sink that is usable by someone with a disability with a 30 by 48 inch clear floor space parallel to it. And your light switches and outlets have to be lower than 48 inches and higher than 15 inches. Phew, did you follow me? That was a lot, right? Okay, let's go on, and in a few minutes, I'll show you some pictures that'll make this a little bit more real. Next slide, please. So how do you focus on a property if you think it might comply? Okay, do a drive-by if you don't live there. Go to the website, look it up, see what the story is, look at the photographs and the floor plans, download them. My favorite, look at any available Google Earth images. Why do you want to look at Google Earth images? Well, first of all, it may give you a view for up above of the property, so you can see what the layout is like. And secondly, in a case that I handled not very long ago, someone claimed that the reason why there was a whole bunch of steps was because there were hills on the property, and they just had to have steps because of the slope of the ground. So I went to the Google Earth images, which showed me a picture of the location before the community was built. Guess what? It was flat as a flitter. So, you know, that's so much for their argument that they had all these hills there. They built the hills. They moved the dirt around. They built the hills, made steps, and then claimed that they had to build the steps because of the hills. A court that has been presented with exactly that problem almost laughed out loud while the court rejected the argument. I'll give you the citation if you ask me. Okay, so if you're focusing on the property, that's part of what you do. Next slide. Okay, now we're into the part about looking for the connected properties. This is where you start thinking about, do I have a case against a bigger case than just one property? So a lot of people get concerned about their own experiences, but they also are seeking justice. And justice often means making sure that there are not other properties built by the same, owned by the same owner, or built by the same developer, or designed by the same architect somewhere else that have the same problems. So looking at the owner, the developer, and the architect, you can see whether there are properties that, other properties that they have designed, and you can look at those properties as well to design the case, a case that may in fact be a systemic accessibility case. Often one where the same problems are repeated over and over and over again. For you attorneys out there and advocates, this means the possibility of getting significant changes by against a builder, developer, and architect, and getting corrections undertaken at all the properties, not just at one. The statute of limitations for filing a complaint in federal court is 2 years, and it's a little challenging. So let me explain this. When do you count from if you're talking about the statute of limitations for filing a design and construction case? Well, the courts, perhaps not surprisingly, are all over the map. So there's one court that said it's 2 years from the date of the last occupancy permit, period. So if your property was built in 1996, you're out of luck. Well, none of us at the federal level who practice these cases thinks that that's the right answer. And in fact, the Department of Justice and HUD have specifically said in a joint statement that they issued about access to housing. It's an interpretive guidance piece. It is easily available online. Look at joint statement, Google, joint statement, HUD and DOJ, access, you'll find it. And one of the questions and answers, and I gotta say, I've forgotten the number, but it might be number 54. It's one of the questions at the end. And it says, first of all, that the statute of limitations begins to run when someone is injured by an unlawful practice. And so if someone moves in and didn't have a problem, and now they're having a problem, now they're injured by the lack of accessibility, you count, I think, from that date. If you have testing evidence or someone looking for housing and they have an experience that shows them that the property is inaccessible, I think that's when the statute of limitation applies. And many courts have now said that you can have a continuing violation if you show a recent property built within the statute of limitations. If you have other properties that are similarly have similar or the same or similar owners, designers, and architects, and similar violations, you can capture all of the properties using a continuing violation theory. It gets a little tricky sometimes, but I think in most cases, the people that I work with, even defense counsel, say that that's the appropriate interpretation of the law. And so even if you've got confronted with a property that was built a long time ago, if you can find that the same builder, designer, owner has another property that was built more recently with the same problems, then you can definitely get in federal court. And you may find a different interpretation under state or local ordinances as well, even for properties that were built some time ago. That's the right answer, by the way. The right answer is that the property is out of compliance and the statute of limitations continues to run until the violations are remedied. If someone had a 6-year-long practice of discriminating against Latinx families and said so, and they were still continuing it today, we would say that's a continuing violation that goes back until that manager came in and started the process. I think that's probably the most appropriate argument for statute of limitations in accessibility cases, and it's the one I argue the most. Next slide. For those of you who are doing these investigations, I urge you to keep organized records, a similar common record keeping system to keep the data. If you download something, keep the link and make a screenshot of it, because sometimes those documents disappear. When you keep the web address and the date that you did the download. So if you did a screenshot of a apartments.com listing that showed an inaccessible route in a property, then take a screenshot of that and date it and save it in your system so that you can show what it was like, even when they take the photographs down, as they did in one of my cases once they realized I was looking at them. And also look for other application or rental policies that may be discriminatory as part of the review. Interestingly enough, many accessibility cases present to advocates like this. Hi, my name is Sara Pratt. I use a wheelchair. I have an apartment and the landlord has just refused to give me an accessible parking place. And I think I should have one, I need one. And so it comes in sort of as either that kind of problem, or someone comes in and says, I asked my landlord for a ramp to get up the 2 steps to my front porch, and he refused. Is there something I can do? In both of those situations of looking for accessible parking places and trying to modify something about the property that is not working for a person with a disability, the case may appear that way, but there is often a design and construction case lurking underneath, which is why you go back and check. If there's 2 steps at the front door and the property was built in 1998, that's a potential accessibility violation. And there may be more violations besides the one that was identified about the 2 steps. In fact, it quite likely is. Again, I'm aware of a case right in your backyards, folks, that started out with one person who was starting to have some trouble with the steps to her condo, and who became the tip of the iceberg for a much bigger investigation, a lawsuit and a settlement over the lack of accessibility in the property at large. Okay, next slide. On-site investigations. So this is the free advice for people who, spurred on by this training, decide that they will go out in their car and drive around a few apartment complexes and look and see if they're in violation or not. So I used to tell people when I traveled to other parts of the country that I would rent a car and I would drive out and look at apartment complexes while I was there. I was young and enthusiastic. I'm not quite as likely to do that today, but you can do a drive-by. And for people who are doing testing-based investigations or their own investigations, driving by can show you violations that are problematic. Take a look for the accessible route to the office. Is there an accessible route to the office? And is there accessible parking space at the office? And the ADA requires at least one van accessible parking space at an office, because a rental office is a place of public accommodation. So are there accessible parking places, and is there at least one van accessible space? And are there other accessible parking spaces with curb cuts and signs around the property? Those are easy to note in one circulation around a property. So you're looking for the number of accessible parking places, you're looking for residents and for visitors, and you're looking at the clubhouse and the other places that had parking to make sure they have at least one accessible space. And then you look around for accessible routes. And let me just tell you that sometimes you will see things that just amaze you. Frequently seen is accessible parking places blocked by a property vehicle, like a golf cart or a maintenance truck. They pulled in the accessible parking place and they're blocking it. That's a violation, right? But also looking to see whether they've got accessible routes that go to the various places that you would go if you live there, like the entrance to the laundromat. I've got a picture somewhere of the entrance to a fitness center being up 2 steps, because that's the way they designed it. And, you know, people with disabilities, that's a public and common use area, and people with disabilities want to go to fitness centers just like everybody else was. And looking at the front door of the units, there's 3 things you look for. 1, that accessible hardware, does it require pinching and twisting, or is it lever hardware? That's 1, does it have the right hardware? 2, what does the threshold look like? That's the metal part that mediates between the interior floor and the exterior, right? And then at the door itself, under the door and under the threshold, when you look at the door, do you see like the step up before you even from the stoop to the door? Like there's a 4x4 underneath it, or there's bricks underneath it. If you see any one of those 3 things, that is not an accessible entrance. And like I said, you can see it from your car. Okay, that's your drive-by instructions. Go, if you see this and you're interested in this as an advocate, please go and work with a fair housing organization or disability rights organization to build your case. There are issues about individuals who drive by and try to file lawsuits. They run into a lot of criticism because they actually didn't want to live there. And they may be challenged in court successfully from bringing the case. And lawyers, I'll tell you the same thing. Work with a disability rights organization or the fair housing groups to help build the case. The organization will have standing to file as an organization. Individuals who serve as testers will also have standing potentially to file. And people who live there who have disabilities who've been injured can also file complaints and have standing under the Fair Housing Act. As we fair housing lawyers like to say, standing in fair housing cases is as broad as the Constitution allows. It's withstood a lot of scrutiny in the last few years, but we're still looking pretty good on standing. All right, deep cleansing breath. Okay, now we're going to go, next slide, to talking about some of the most common mistakes that we see in design and construction complaints, so that you too will know what you're seeing might be a potential violation. Okay, next slide. So the first most common area, and the biggest mistake is the developer, the owner, even the architect have no idea what they're doing. They do not know. They do not know that there's a Fair Housing Act, or if they do, they have no idea that it applies to what they're doing. And really the most common area is that that developer, builder, or architect doesn't even comply with state or local codes about accessibility, because in most states they do exist, and in most states they're not so bad. But when you drive by a property and you see no accessible hardware and no on doors and no accessible routes into apartments and steps leading up to the stoop, they are not complying with state or local codes, and they're not complying with the Fair Housing Act, almost 100% for sure. Okay, next slide. All right, so the biggest structural areas are the lack of an accessible route to units. There are steps, there's slopes, there's a big step at the primary entrance or the front door to the property, and there's a high threshold at the entrance door. Next slide. Here you go. Look at it. So these units are flat units. They are not townhouses. They are, there's a unit where you see two sets of steps. Each set of step goes to a separate unit and a little sort of porch. And then to the left and to the right, there's the entrance to the flat unit, right? These are not townhouses. And so this is very common. The door to the steps to the left, by the way, goes into a common door that goes upstairs, that goes to a hallway, and then has interior steps to go to the units upstairs. So it's 2 level stacked flats. That's what we call them. They're flat units, and there's 2 sets stacked on top of each other. In this case, because there is not an elevator, the ground floor units, 100% of them have to be accessible. And here what you've got is steps to every one of them, and you can see it from your car. Okay, next slide, please. Here's a shot of a door, a primary entrance door or a front door. See those bricks underneath? You can see them from your car. That is a step up. It's probably 4 inches, and it is completely illegal. It's a high threshold. It's a level change between the interior floor, which is shown on the inside, and the stoop or the patio, which is below. And that level change is 4 inches, which is about 3.5 inches higher than it should be. Okay. Again, you look at the front door from the car, you see the front door, and underneath it, you see this sort of 4-inch high step violation. Okay, next slide, please. Here's a couple of pictures that show how you measure. And some of these doors might actually be a little familiar, I think. So do you see how the threshold, how the picture on the right is showing what the threshold is? This threshold design, although it kind of looks okay because it's sloped, is still too high, right? And it is considered to be inaccessible. And in addition, it has this metal or wooden ruler-like looking thing on the top of the threshold that makes it too high. And so this threshold does not comply. And this is how you measure it. You take in this case, a level, and you take a tape measure, and you measure it with the tape measure, and you use the straight across, could be a ruler or a stick, and measure how high the actual threshold is. Next picture, please. This one, I can tell you. So first of all, if you can see this at all, you can see that the doors have round knobs on them, which means that the door hardware is not compliant. This is a property where we had a case that was settled. Looking at this picture, what probably happened is that there were steps to the unit sort of in the middle of the picture, and somebody came along and said, oh, that one has to have an accessible route. So they built a really bad accessible ramp to the sidewalk. That ramp is way too steep. It also has cross slopes, which you can't tell. And it's required, if it's a ramp, to have a handrail on both sides. This ramp would be very dangerous for someone with a disability coming down it, because there's also not enough flat area at the end of the ramp for them to stop and turn before they were in the middle of the sidewalk. I think the expert that examined this one for purposes of their case found 8 or 9 violations in that one ramp. But just looking at it, you can kind of eyeball it and see there's a problem, can't you? Okay. Next slide, please. Yeah, this is one of my favorite ones. This is how somebody decided that they were going to make an accessible route to the office, which is behind what you're looking at. I'm sorry, the clubhouse. So you see the clubhouse, and there it's got 1, 2, 3, 4 steps and handrails. Isn't that lovely? But wait, how do you get? Wait, you can't get from the alleged curb cut, which, by the way, that little slanting down and then just building the concrete right back up in the sidewalk is not a lawful curb cut. People do it all the time. But the reason why it's not accessible is because for someone who's vision impaired, who's walking down that sidewalk, the running slope is fairly steep and it drops off fairly quickly. And so somebody with a vision impairment could trip. So a curb cut actually has a flat space outside of the curb cut to allow a person with a vision and disability to go around the curb cut so that they have a really flat walkway, an uninterrupted flat walkway. This accessible route goes exactly nowhere except steps. Okay, see the problem, right? Okay, next slide, please. I know exactly where I took this picture, and it was near Toledo, Ohio. Take a look. What do you see? Who remembers how wide an accessible route is supposed to be? You know, the accessible route that gets you around the property? Was it 36 inches? Yeah, it was 36 inches. So how wide would you say that sidewalk is, given all those cars poking their noses over the sidewalk? Is it 36 inches? No, maybe 26, maybe 26. So this is a design flaw that really creates big problems for people with disabilities. And it's an ongoing pain in the, you know what, neck. It's a pain in your neck. Because if you're trying to get to the clubhouse, which is the building to the left, and you see down there a very inaccessible and very steep ramp, you can't get there because of the parked cars. The design failure here is somebody built the sidewalk right up against the parking lot. So there is no extra room for the cars' noses, hoods, or rear ends to poke out, not to be protected from the sidewalk. So the solution for this, some of you know this answer, is to install car stops, concrete car stops that are inserted in the asphalt that stop the tires of the car before they get right up against the curb and keep the car back away from the accessible route. So you can fix it as a design, the design way, but it's the cheaper fix once it's designed is to put in car stops everywhere so the cars will not poke over the accessible route and interfere with it. By the way, that I didn't have a good picture of that so-called ramp that had a slope of about 18 inches that was designed, thrown up after the property was built as an alternative to steps to make it accessible. It is not a compliant ramp. A compliant ramp has a slope no greater than 8.33% or 1 in 12. So 1 inch of rise for 12 inches of run, right? And this one is much steeper than that. It also was lacking the appropriate handrails that have an extension on the end so someone can hold onto the handrail even when they take the last step. Many violations shown in this picture. Next slide, please. Yeah, this is the violation I mentioned before where you have the side, the cross slope that exceeds 2%. This one is 3.1%. I know you can't see it in this picture, so I'm telling you, use your imaginations. It's 3.1%, and it varied off and on down the scope, down the sidewalk. So, and none of them were under 2%. So this is a problem because if someone is in a wheelchair or using a walker or even a cane and walking down the sidewalk or up the sidewalk, that if the slope is excessive, the person can be pulled in their wheelchair, they're over to one side or the other, and it creates a serious problem in terms of maintaining your status on the route. And in this case, because the slope is going downhill, the person would fall over into the parking lot potentially. If you've ever pushed somebody in a wheelchair, you can feel that problem too. Okay, next slide. Okay, those mailboxes. So this was someone who was taking a measurement of the part of the driveway, because in that case, the only accessible route that you could possibly consider to get to the mailboxes was on the driveway. Although there's a concrete sidewalk behind it, there was no curb cut. And the mailboxes face the driveway. So the idea, I suppose, is, well, you could just drive up in your car and reach your mailbox from your car. Except anybody who's tried to do that from their car know that those mailboxes are both too high and too low to be able to do that. So what you have to do is park your car, get out of your car, and walk to the mailboxes. There's so much wrong with this picture. But bottom line is, if you're using a wheelchair and the mailboxes are not on an accessible route, the mailboxes as cited are higher than 48 inches, and I think they're within 15 inches at the bottom, but many of the mailboxes are more than 48 inches above the driveway, which is what you measure from. And there is no actual accessible route to them. What's another way of doing this? The most common way in these clustered mailboxes is to provide an accessible route and a pad, concrete pad, that's served by the accessible route, and have the mailboxes face that pad. It's very nice to also have a covering for all of us, because getting your mail out of a mailbox when it's pouring rain without have some covering over your head is problematic. The covering is not required by the Fair Housing Act. It's just one of those things good designers think about. What about mailboxes? I have a case right now where the mailboxes are on the inside of the unit of the office building, or the main office. They're on the wall and they are too high. So they're mounted, they're clustered mailboxes. They come in big bunches. Somebody stuck them in the wall, caulked around them, and called it a day. About the first two rows of mailboxes are above 48 inches. And the bottom row is under 15 inches. So there's maybe a quarter to a fifth of the mailboxes are not within the applicable reach ranges. And landlords always want to say, well, we'll just assign them another mailbox if somebody comes in. Well, first of all, the property is supposed to be designed and constructed to be usable and accessible in the first place, and not make a change when someone comes in. But secondly, there are also problems with the United States Post Office that continues to approve those kinds of clustered mailboxes for a variety of reasons, including saving the backs of the people who put the mail in the boxes from behind. But they come in certain dimensions, and the product simply is not readily available to provide mailboxes only within the reach ranges. So one way to do this more effectively is in fact to order smaller clustered mailboxes and have them go around a U shape, so all the mailboxes are within reach ranges. But if you run into this into a already constructed property, it's probably infeasible to require them all to be replaced. So what you usually argue for is mailboxes, an additional bank of unassigned mailboxes to be installed nearby, so that somebody with a disability within reach ranges. So if someone needed a mailbox within reach ranges, they can have one assigned to them. The post office does not like to mess around with just reassigning someone a mailbox in any given day. They have a way of assigning it. If you have this apartment, you have this mailbox, and they don't like to mess with that. That's why the additional bank of mailboxes has become a solution in many cases. Okay, next slide, please. Here's another mailbox picture with a different design. Now, this was in the process of being measured. What's the problems with this? Well, here's one. There's no accessible route that gets you up close to the mailboxes because this little 12-inch pad does not allow you in a wheelchair to be on the pad and trying to reach the mailboxes. So you're over there trying to get to your mailbox and you're, I don't know, getting stuck in the mud. Secondly, the operable part of these mailboxes is at the top, and for the top row, the measurement shows that the mailboxes are too high. So this is a poorly thought out design, and it was required to be changed in the design as part of the remediation plan. Okay, next slide, please. This is a picture of a playground. The Fair Housing Act doesn't require an accessible route to all the items in the playground. I've run into confusion on this. Landlords who say, I couldn't put an accessible route in there. The kids would fall off the swings and hurt themselves, whatever. So generally speaking, the accessible route ends at the gate, and then you come in. Now, suppose you've got a client who needs the accessible route because he or she actually wants to put their kid on the seesaw or on the swing. Well, the reasonable accommodation is a mat, such as the ones they're now using at beaches and other places, that is fairly lightweight, that can be rolled out to provide an accessible route over the mulch or the chips to provide access to sort of the playground equipment. Similar ideas for picnic areas, grill areas, and so forth that are inside of a fence like this. Okay, next slide. Oh, this curb cut. There's so much wrong with this curb cut. What they were trying to do, I think, was to save themselves a parking place. Normally, you see the car in the right-hand slide. Normally, that area would have been a striped access aisle, and the curb cut should have been put up at the sidewalk on the access aisle, either at the top of the access aisle or to the left, and the sidewalk adjusted accordingly. But apparently they didn't want to do that, so they put the curb cut down at the bottom of the hill. I can tell you from looking at this, and the expert who measured it agreed, that there is extraordinarily steep slopes here. And if you're in a wheelchair trying to come into this sidewalk using this curb cut, you will have a very difficult time going up towards the car. You will also have a very difficult time because the cross slope, especially to the left, is extremely steep, and you would run a risk of falling over completely. Thereupon, I tell you the story of my case against a public housing authority in Louisville, Kentucky. I represented a couple, both of whom used wheelchairs, who met living in one-bedroom apartments and fell in love and got married, and now they needed a bigger place. And the bigger place, it turns out, because they turned out to have a lot of equipment and an extra kid somewhere, they needed a 4-bedroom apartment, at least a 3-bedroom. So the housing authority, under threat of lawsuit, said, well, we've just built a new 3-bedroom apartment over here in such and such a place. Will they accept that? So I talked to them, and they say yes, but of course it wasn't built yet. So it's finished, and they're given the keys, and they go over to look at it, and they go, no. Then I hired a local code enforcement guy who actually knew how to assess for accessibility. And he found something like 86 accessibility violations in this brand new constructed public housing unit. But the biggest ones were on the ramp. The building design had not been changed when they first designed it to have steps up to the front door of the unit. So when they basically had about 4 feet from the ground up to the primary entrance. So they decided they would address that by building a ramp. This might be the longest ramp in the history of the world. It went on forever, and it was quite beautiful. It was curved. It was kind of curved like the Daytona 500 was curved. In other words, it went up and steep, and then it kind of banked and went around and straightened out and went to the front door. It did not have an area of rest, which is required in long ramps to have a flat place where you can stop and catch your breath before you start on the next rail. Normally you have a ramp that goes up a small distance, and then you have I forget what the dimension is, and then you have a flat area and you have a turn. So you stop, you turn, and then you go up the rest of the ramp. In this case, the ramp was curved. So it was so bad, and there were so many violations, that instead of filing a lawsuit, I called a local TV news reporter and said, "You want a story about accessibility? I'll give you one, come on over." And we put this guy, who was really cute, and maybe 33, 34, and put him in one of my clients' manual wheelchairs. And he looks at the ramp and goes, "Yeah, I can do this. I got the power." And so he starts up the ramp, and he realizes suddenly that it's a lot steeper than it looks. And he's kind of, the muscles are bulging. I'm watching avidly, right up and up and up. And then it gets to the place where the thing is sort of ramped to the right. And on camera, as if on cue, the wheelchair tipped over and he fell off on camera. So that made the evening news that night, and the ramp got fixed within a week. But that's the kind of problems poor design choices can make for people with disabilities. Next slide, please. Coming towards the end here, the lack of van accessible parking at the office is a very common mistake, and the lack generally of enough accessible parking places is another big violation. Next picture, please. So here we have an office. For a building, there's no accessible parking, there's no curb cut, there's no signage. This is where the office is located actually, this is the rental office. And I think the sign that you see over there says something like reserved for employees. So remember, at least one van accessible parking place with signage, a striped access aisle, a curb cut, and the curb cut that actually is a curb cut where there's a sufficient accessible flat route around the curb cut so that somebody walking along the walkway or the accessible route does not have an abrupt step down and trip and hurt themselves. Next slide. So here's what the design looks like. I don't know if you can really see it from where you're looking, but in the picture on the left, they have a wheelchair accessible space. They have signage because you can see the shadow of it, and they have an access aisle. But look at the end of that access aisle. There is no curb cut, y'all. And so what they have happening instead is, I guess they thought because they already had this curb cut on the right-hand side, that was going to be okay. But there's something really wrong with this design. What's really wrong with it, and scary wrong with it, is that somebody who's using the access aisle to get out of their vehicle has to go out into the parking lot to get to the sidewalk. The person with a disability should not have to do that. They should be able to access the parking lot, access the accessible route without going behind parked cars, without going out into an area where traffic will be going, because it is dangerous. The picture on the right shows the correct design for an accessible curb cut and parking space. So you have a striped access aisle, you have an accessible parking place with signage, and notice the curb cut, how the curb cut has the wings that have slight slants in them, and there's not a huge amount of slope, and then there is a flat alternative route that allows you to get around the access aisle in a wheelchair. So that's got to be at least 36 inches wide. Or if that works so that people do not have to go along the accessible aisle and then down into the curb cut and then back up again. That is not proper design. Next slide, please. Oh, and one of my favorites. Here's the accessible parking place. There's a wheelchair right on there, and there is no access aisle and no curb cut. So this is a significant violation, and it creates an even greater problem that someone in a parking space who's trying to use the accessible parking space cannot get out of their car, or if they can get out of their car, they are behind they are moving behind parked cars in a parking lot, which is dangerous, to try to find a curb cut. Next slide, please. Yet another poorly designed parking space, a curb cut that shows both steep slopes, poor design, and the curb cut puts someone out, dumps them out right into traffic. I mean, and with a grade ahead of them. At the very least, if you have a curb cut that's not coming out into an access aisle, you should have a crosswalk there. Supposedly, this curb cut was supposed to access parking garages that were behind to the right off camera. And so if that was what it was for, there should have been a striped access aisle or cross-hatched crosswalk to show that there was somebody with a disability crossing there. But also the design is not a proper design of a curb cut, and it's got excessive cross slopes in the design. Again, the expert who was taking measurements here found multiple violations. Next slide. We're coming towards the end. I'll get your questions ready. No accessible garages. Not every garage has to be accessible, but an accessible garage has a pedestrian door, not just a garage door. And that's because garage doors are heavy. And so, and especially these which didn't have remote controls, but even if they have remote controls, you have to have a doorway that a person can go in and out of to get in and out of the garage that is not the garage door itself. And that becomes important if the garage door is automatic, but the batteries run out, or it becomes important when someone doesn't have the upper body mobility to operate a garage door. Typically only one garage has to be accessible in that way. Funny case, and some of this will be familiar to people hearing me today. There was an argument made in one of our cases, so interesting. It was a case where there was a garage built into the unit. And the argument was, well, we can have steps at the front door or the primary entrance door because there's an accessible route from the garage. So you could drive your car in and have an accessible route in that way. The Department of Justice has spoken on this issue. In the case that we were working on, the Department of Justice said that is not at all what we mean when we say a primary entrance has to be on an accessible route. We mean what we say, the primary entrance that is used by the public, FedEx, deliveries, people selling cookies and candy, trick-or-treaters. The primary entrance door has to be the one that's on the accessible route. So it doesn't do you any good if you're trying to visit the person and come in the front door and you've got 3 steps. They're not coming in through the garage. DOJ supported our position in that case, and it's a good thing. So no, you cannot have an accessible route through a garage. Next slide. Here's just a quick picture of a pantry. This is a pantry on the inside. Doorway closets. Normal walk-in closets can have narrow doors. They can. Narrow reach-in closet, like a coat closet where you just put your arm in, hang up your clothes. They can have narrower doors. But any closet that is deeper than 24 inches, say a walk-in closet or say a pantry, has to have that clear opening of 31 5/8 inches at the door. And here is probably someone in this group listening, taking a measurement of that door. Next slide. And here's that stove stuck in a corner. A person with a disability would have especially people using a wheelchair or a walker, would have great difficulty reaching that stove. They would have a hard time reaching the control on the backs because their knees would hit the door of the stove before they were close enough to reach the burners or the controls. This dimension was also being measured because there's a certain kind of kitchen that has a 60-inch turning radius. And that measurement was being taken to see if that kitchen had a 60-degree turning radius. But even if it had a 60-degree turning radius, the stove should have been in the middle of this U shape, not on the side. Next slide. So here's some measurements that show a stove that did not have the clear floor space beside it and the dimensions that were a problem. Next slide. And here's someone measuring the sink in a bathroom, I think this was people I know taking these measurements. You measure from the wall of the sink to the midline from the wall where the lavatory is located to the midline of the sink, which in this case is where the faucet is. And you measure that dimension, and it should be at least 24 inches. It is not in this picture. And so for bathroom sinks, the clear floor space is so somebody in a wheelchair can pull up beside the sink and have at least 24 inches behind them so that they can lean over and brush their teeth. The ideal is a sink with a forward approach that's built up like a wall hanging sink so that people can pull up underneath it and brush their teeth straight ahead. But the Fair Housing Act design allows you to have a side approach, but it has to be at least 30 by 48 inches so a wheelchair can get in there without the tires sticking out the doorway so someone can lean over and brush their teeth. Next slide. And here are some measurements that we were taking in the bathroom of the same property. We were measuring measure from the toilet. The midline of the toilet has to be between 16 and 18 inches from the side wall so that if somebody puts in grab bars, they can use them. And the actual measurement here is from the end of the toilet to the adjacent vanity. You have to have enough space in there so somebody could pull up in a wheelchair to the toilet. And there was not enough clear space at the toilet. So a lot of these are dimensions that would be much more complicated than you would take note of unless you lived in the property or unless you were doing an investigation to take these measurements, which is what some of the people in these pictures were doing. Next slide, please. So you don't have to remember all of these. The big ones are the ones that I mentioned when you have the drive-by and the ones that you can look at and kind of notice as you go through a property. If you identify the basic problems, then you can identify them and work with an advocate to get a more organized expert inspection or detailed inspection by people with tape measures and cameras. Next slide, please. Here's a list of resources, how to get resources. The Fair Housing Act Design Manual is downloadable for free from HUD. The Fair Housing Act, Fair Housing First FAQs, key issues case law are available. The HUD Fair Housing Accessibility Guidelines are available online, and those are where I got the dimensions I talked about today. And there is this joint statement on accessibility that is available for easy download and reference as you're working on developing these cases. I'm happy to take questions at this point.
Thank you so much, Sarah. We do have a few questions in the Q&A. The first question that came in, I took the liberty of answering. Someone asked if a pre-1991 complex is rehabbed in 2022. Does that require accessibility compliance at that point? Obviously, they saw the answer that no, rehabbed properties are not covered. The other question that I answered, I'm sorry, are tiny homes as single-family dwellings covered by the Fair Housing Act?
Right, and I'm sure you said they're single-family homes, and unless they're attached to each other, they're not covered.
Exactly. So unless they were attached, they would not be covered.
Although I will say, if you're building them with federal money, say COVID relief money or other resources from the federal government, they might be covered by other laws, including Section 504.
Yeah. So another question, does HUD require any HUD subsidized pre-1991 complexes to comply with accessibility requirements when HUD actually rehabs those aging buildings?
Yes, not under the Fair Housing Act, but under Section 504. When you're renovating older properties, and this does happen, HUD's regulations under Section 504 require that the rehab include accessible design. And the idea is that all the units that you're renovating have to be made accessible unless and until you have at least 5% of the units being fully accessible. So if you're doing all the bathrooms, say, for example, and that's all you're doing, every single bathroom has to be made accessible unless you already have at least 5% of your units that are fully accessible. So a lot of the older properties are not fully accessible. I lived in one of them once with my husband and it was not compliant. So the entity that is looking at this should look very carefully at 24 CFR Part 8 and the regulations there and seek legal guidance on what the steps are that they need to comply with when they're renovating HUD subsidized properties so they don't make a mistake.
Great, thank you. The next question we have, is it common in these cases for all workers on the project to be charged or brought into the lawsuit?
So it is common to see the owner, the developer, the architect, and sometimes the civil engineer. The people who are lower down the scale, they say the electrical contractor who put in the light switches are usually not brought in. But it's I mostly see the owners, the managers, the developers, and the architects, and maybe 50% of the time the civil engineer, depending on what the violations look like. Those are the key ones brought into the case.
Thank you. The final question we have, when the court finds that a property is in violation of the design and construction requirements, what remedies are typically pursued? Money damages, specific performance? It seems like the best deterrent is to make the defendants correct the problem.
It is, and almost all the cases that HUD has brought, that the Department of Justice has brought, and that private litigants have brought, they seek remediation to the extent that remediation is possible to fix the problem, both on the outside and on the inside. If it is infeasible to fix something that's already been built, then we often include a remediation fund that allows tenants to request remediations to individual units. And sometimes we require future accessibility and higher levels of accessibility in future construction if the property is if the entities are continuing to design and construct properties. We typically require training and external third-party independent inspections to make sure the corrections are done correctly. And sometimes there are significant damages for individuals or organizations, and sometimes even punitive damages, where the people were told of the obligation and failed to comply with it. And, you know, whether you seek that in a case that goes all the way to court and has a jury trial, you can seek all of those remedies. A typical settlement includes some or all of those provisions in them.
Wonderful. So if anyone has any other questions, you can put those in the question and answer now. But it is 12 o'clock, so I'll hand it over to Katie to wrap things up.
Well, thank you. And thank you to Sara for that wonderful presentation. I know I have a couple questions just from listening that I might follow up with afterwards. And we appreciate you being here and adding so much to the seminar series and helping us educate potential advocates and, current advocates, as well as anyone else listening in on what's required under the Fair Housing Act.
You're very welcome. I'm glad to do this. People can reach me at spratt@relmanlaw.com, or Katie and Christina both know how to reach me directly if people have follow-up questions or want to talk about a case.
Excellent. Thank you so much. For everybody else, we want to invite you to join our sessions next week. This is the last session of this first week of the seminar. So next week on Wednesday, October 19th, we have Gina Wilt, who's the Advocacy Director for Co-Ohio, who'll be presenting on the intersection between housing and health and the state of housing and homelessness in Ohio. On Wednesday, October 19th at 1, we have a panel of disability advocates who will be discussing personal experience in housing barriers for folks with disabilities. And then on Thursday, October 20th, from 10 to 11:30, Dr. Larry Clark with the Monroe Street Neighborhood Center will be presenting on their project, the Bluff Street Village. which is a tiny home project here in Toledo, Ohio, that they worked with us to make completely accessible. Just a reminder that all materials, the recording and the transcript will be on the website, and we're hoping to see you guys next week. So thank you again, and thank you to everybody who's attended. We'll hopefully see you in a week when we restart our seminar.